with new clauses and import non-beneficial encrusted clauses into their contracts, and how agency costs affect those drafting decisions. Jonathan Lipson suggests that proponents of corporate social responsibility should look to contract law rather than to corporate governance to achieve their goals. Gabrielle Rauterberg will address property contract process in organizational instruments as a way of understanding how organizational instruments differ based on whether they are consented to or not. Robert Thompson examines the phenomenon of contracting out in closely held entities, VC-backed startups, and publicly held corporations, and the remaining limits on contracting out. Juliet Kostritsky is presenting for her co-authors, Gillian Fox and Blake Spiller. She will address how the ambiguity of environmental social governance terms mandating the pursuit of ESG would be analyzed under contract law and corporate law. And now, with great pleasure, I turn to our keynote speaker. It is a real honor to welcome Professor Jill Fish to be our keynote speaker. She is the Saul A. Fox Distinguished Professor of Business Law at the University of Pennsylvania Law School and a professor of finance at the Wharton School. She is also a director of the European Corporate Governance Institute, which publishes many wonderful papers. She is a graduate of Yale Law School, where she was senior editor at the Yale Law and Policy Review. She has been a visiting professor at Harvard, Berkeley, Georgetown, and Columbia. It is hard to overstate what a pivotal role Professor Fish plays in addressing the most important issues facing firms today, many of which involve the intersection between contract and corporate law. She has written on shareholder agreements in private ordering, contracting out of shareholder appraisal, governance by contract, the implications for corporate bylaws, and shareholder collaboration. Her scholarship illuminates the key intersections between contract and corporate law, the very focus of this conference. She has also written on securities issues. Her most recent article, co-authored with Quinn Curtis and Adriana Robertson, is entitled, "Do Mutual Funds Deliver on Their Promises?" which is forthcoming in the Michigan Law Review. Her expertise also extends to financial literacy and retail investors. We are thrilled to have Professor Jill Fish here, and I don't want to take any of her time away. When I asked her to participate, she readily agreed, so long as it was an in-person event. So here we are, and we could not be more fortunate that she has joined us for the Leet Symposium.
Do I have something to control the slides or do this? Oh, okay, great. Well, Juliet, thank you for that warm welcome. And yes, I like speaking to real faces and not to a screen. So a special thanks to those of you who made the effort to come today. I really appreciate it. And I know that the later speakers who are here in person appreciate it as well. So yes, when you read through that work, Juliet, it sounds like I've written a lot or thought a lot about corporations and private ordering. And I have to say, I haven't figured very much of it out. So this is going to be sort of more musings than answers. And I welcome your questions and reactions. So the sort of idea of a corporation as a contract has been around for a long time. And I don't know if you can see, yeah, I guess I have the date on there. So around the time, I hate to admit this, around the time I started teaching, there was this Columbia Law Review Symposium on contract theory of the corporation versus the old concession theory. And at that time, it was a pretty lively debate. There were a lot of people who said the corporation is not a contract. There are a bunch of mandatory rules. There should be a bunch of mandatory rules because the corporation takes its authority from state law, and states create corporations with particular objectives in mind and with particular structures that hold the corporation accountable, both internally to its constituents, but more broadly to the state and to society. And I think one of the things that we worry about today is the breakdown of those accountability mechanisms. Now, I won't pin the fault for that breakdown on the contract theory, but it's something to kind of keep in mind. In any event, I highly recommend the 1989 Symposium to you. Some great scholars wrote in it. I did not, because I was only starting in teaching. But, despite that lively debate and despite really good arguments on both sides, what we've seen since that time throughout my career is a growing domination of the contractual theory, right? The contractarians have more or less won out, right? So, yeah, go ahead. All right. So we see this particularly in Delaware. Delaware, of course, is the center of US corporate law. We see this in the Delaware courts, an increasingly expansive view of the corporation as contract, and a recognition of the broad freedom of corporate participants to rearrange, to modify, to deviate from statutory constraints, not just in situations in which the statute expressly says you can do something differently, but even where the statute is silent, or in some cases, even where the statute appears to create an affirmative obligation. And I'll talk about that a little bit more, right? But this broad language in the courts, right? Now, this is consistent with what's been going on in the Delaware legislature, right? The Delaware statute, the corporate law statute, has generally been described as an enabling statute, meaning it allows a lot of private ordering. But if you look at the last 20, 30 years of amendments to the Delaware statute, we see even more amendments that authorize private ordering. And it almost seems like every time a practitioner thinks of something that they might like to do in a charter or bylaw provision, the Delaware legislature says, okay, just in case there's any doubt, here's statutory language, you can do this, right? Now you're all cleverly thinking, oh, but what about fee shifting bylaws, right? And that's my exception that proves the rule, right? But, by and large, right, lots and lots of provisions, allowing contracting out of everything from directors' fiduciary duties in the case of 102B7 to violations of the corporate opportunity doctrine in 122.17. And you're going to say, well, it's not really contracting out of fiduciary duties. Wait, right? I'll hone in on that point a little bit more later. But okay, right? So why have the contractarians won? Right? What's the story? Well, there are a lot of defenses of the contract analogy, both from a sort of legalistic perspective and from an efficiency perspective. And I'm not going to go through all of them here. You've got great scholars in the room who have written on a lot of these topics. But from a pure contract approach, and let me just be clear, I don't want to commit malpractice. I'm not a contract scholar. I've never taught contracts. I didn't learn very much about contracts in law school. You will remember, and I'm not going to repeat it, but Juliet told you where I went to law school, so it's no surprise that I didn't learn a whole lot about contracts there. But in any event, I know this is being recorded. In any event, right? There's a lot to like about corporations from a contract perspective, right? The idea that, well, you've got these documents, the charter and bylaws, that look like they're allocating rights and responsibilities among corporate participants, much in the same way that a contract does. There are tools for modifying those rights. Shareholders, when they buy into a corporation, it's a voluntary choice. Nobody has stock thrust upon them, right? Shareholders are not becoming participants in corporations under duress. Even the employees that are not worries about. It's not quite duress. It might be close, but it's not there, right? And you have all sorts of controls with respect to if the board or the shareholders sort of gets too rowdy, runs amok, takes advantage of their ability to modify the contract terms or needs to input new terms into the contract. Both the board and the shareholders under Delaware law have the power to amend the bylaws, right? Charter has to give directors that power, but the charter invariably does. You have director elections, you have outside control contests that discipline the use of these contractual tools. So it looks like it is flexible. It looks like it governs the things that contracts would govern participants to the contract. It looks like it's voluntary. Looks like there's at least implied consent. Again, from my outsider's perspective with respect to contract law, I buy the argument that people like Strine make that this is like a contract. Right? There's also a lot to defend in terms of the objectives of a contractual approach, right? So this idea of private ordering. Right? Number one, all firms aren't alike. If we were going to have a statute that set up corporate structure and had a uniform set of requirements for all corporations, well, that statute wouldn't get it right for every single corporation. There are corporations in which shareholders need more power. There are shareholders in which directors or the CEO needs more freedom, more flexibility to operate however he or she sees fit, right? Think Elon Musk, he needs a tremendous amount of flexibility and absolutely no corporate constraints at all, right? So, you need that kind of flexibility. You've got different ownership structures, right? So a corporation with a controlling shareholder might need different checks and balances than a corporation that is held primarily by institutional investors, or a corporation that's held by dispersed retail investors, or a corporation like many Midwestern corporations that's very much held by employees, former employees, and investors in the local community, right? Those corporations vary, their needs vary. A startup company that might not be profitable, it might have a long on-ramp before its innovation is going to be fully developed, might need a different corporate structure than a mature company that basically, if anything, it needs a little sort of prompting so that it doesn't just keep running in place, right? So that those differences among corporations call for variation in the structure, and private ordering allows that kind of firm-specific tailoring. In addition, even if we said, well, we're worried about whether, investors will be taken advantage of and private ordering is going to be controlled, usurped by management, we are concerned about whether regulation is superior to market forces in terms of getting it right? It's hard to know exactly what the right corporate structure is. I think about the empirical literature on corporate governance, right? And I've been living with and reading this empirical literature for years and years. And there's tons of people, increasingly now in law schools, but originally in finance departments, that were studying things like anti-takeover defenses, staggered boards, poison pills, independent directors, performance-based compensation, you name it. And what's the common theme among all those empirical studies? The evidence is kind of mixed. We don't really know. We can't point to the literature and say definitively, yeah, that's the good corporate governance. That's the right answer. I remember at one conference several years ago, going to the head of corporate governance, one of the big three institutional investors. And Juliet, I'm going to amend big three because I always want to add fidelity. I always feel like fidelity gets left out of the equation. So I'm going to call them the big four. Right? But I went to one of the big three or big four corporate governance, and I said, heads, and I said, you've got these voting policies that require you, or where you decide you're going to vote pro or against all of these corporate governance mechanisms. And the literature's pretty mixed, right? Why are you so sure that, say, a staggered board is bad at every company, right? I can think of examples where having a staggered board kind of worked out, right? And I teach my students the Airgas Air Products case as the example of that, right? Well, maybe it wasn't such a bad thing for Airgas to have a staggered board. Right? So I said, why are you doing this across the board as opposed to having a very specific policy? And he couldn't give me a very good answer. His answer is, well, on the whole, right, on average, more times than not, it seems like getting rid of the staggered board would be a good thing, right? Well, I'm not super happy with that voting policy, but I think it would be worse if we, say, banned staggered boards as a matter of government regulation, just because more often than not, staggered boards reduce value. right? And you see the same debate more recently with respect to dual class stock, right? Is dual class stock good or bad? I don't know. There's a lot of literature on both sides of the question. Maybe it varies. Maybe for some firms it's good, and for some firms it's bad. And of course, there you are back to private ordering, right? Let's let the firms sort it out. Let's let the market sort it out. And even if for an individual firm, it's a bad choice and the firm gets it wrong, seems to me that's better than having a whole, a whole corporate law suffer the wrong answer. So, that's part, there's a whole lot of literature in this. I'm not going to go into detail on the defense of private ordering, but those are some of the reasons why, from an efficiency approach, we might think that kind of flexibility through contractarianism makes sense. So, as I said, we have the tools inherent in the way the corporation is set up. A corporation is regulated by statute, but a corporation individualizes its structure, its balance of power, its accountability through its charter, right? And statutes say the charter has to have this minimum. The senior professor from whom I took over teaching corporations when I first started teaching, had students draft a charter. That was one of the exercises they had to do every year. It's not hard, right? Takes about a page. There's 5 or 6 things you have to put in there, right? This is not terribly complicated, right? But if you go online, if you look at the charters of publicly held companies, you see they're longer. There's lots of variation. There are optional provisions, right? That's a place where private ordering occurs. Same thing with respect to the bylaws, right? And I was talking a few minutes ago about the bylaws. Corporations use bylaws even more. And in part, they use bylaws more because it's easier to amend them, right? And because either the board or the shareholders acting unilaterally can put new provisions, can respond to problems, put these things into place. Finally, and in particular in privately held companies, corporations are increasingly making use of shareholder agreements. Now, Gabe isn't here. I don't know if Gabe is even listening, but Gabe is, of course, number one, pioneered a lot of the research into shareholder agreements and shown that shareholder agreements are not limited to private companies. There are a number of public companies, a surprising number, that are using shareholder agreements. Anat has focused on shareholder agreements in the distinctive context of employee shareholders, right? Shareholder agreements are a growing tool and they present some distinctive concerns, and I'll talk about them, right? But those are the tools that we have, the contract type tools, right? So the title of my talk is limits, right? And you might be asking yourself, well, are there limits? And if there are, where do they come from? Why should there be limits, right? Those are the questions that I'm kind of struggling with. So that's the late Bill Allen, Chancellor Allen, who said, in the midst of this debate over concession versus contractarianism, corporate law isn't bereft of mandatory terms. What are those mandatory terms? How do we know? Where do they come from? And the Delaware courts recently have been struggling to answer that question, right? So here are some possibilities. Let me just let me sketch out a couple of possible limits of contracting. And let me give you a couple of examples then to stew on, right? And we can sort of see how these various limits might or might not work. Right? So one limit is statutory limits, right? If the statute says you can't modify this by contract, presumably you can't. And there are a couple of examples, even in the flexible enabling Delaware statute, where the statute does that, right? So the statute says you can't adopt a fee shifting charter or bylaw provision. Absolutely clear. The statute says you can't exculpate directors for violating the duty of loyalty. Absolutely clear, right? So great, we're done, right? That's the source of limits. When it says in the statute you can't modify, you can't modify. Problem is, there are relatively few of those limits. I think any person who believes in the contractarian model might at least be suspicious that those are the only limits, right? So what about, right, and that's an example of the 102B7 language, right? Because you don't all have your statutory supplements open in front of you. I did this for my students too, right? So, such a provision shall not eliminate or limit the liability of directors, pretty clear statutory language. All right, but what about when the statute doesn't say you can't do something, but the statute says you shall do something? Does that mean you can't contract around that? For example, the Delaware statute says a corporation shall have an annual meeting. You can't have you can't have a charter provision say it says we're getting rid of the annual meeting. Well, just recently, the Delaware Supreme Court decided the Manti case. The Manti case deals with appraisal rights. The Delaware statute says shareholders shall have appraisal rights. And the Manti court, the Delaware Supreme Court, says shall, but shall doesn't really mean shall. Maybe shall means may. But it turns out that that language wasn't a hard limit. So if we're looking for statutory language, we might not ultimately be super satisfied, right? Here's another example. The board of directors in a merger shall adopt a resolution approving an agreement of merger. Well, what if I set up my corporation and I put in a charter? In this corporation, the decision to merge will be based on a supermajority vote by the shareholders. We don't need board approval, right? Shareholder vote alone can approve a merger. Is that okay? Private ordering, right? Maybe I'm worried about the board of directors. Maybe this is a corporation in which shareholders need more power. Maybe I'm worried about conflicts of interest in mergers, right? There's always that risk. Right? Think about, what's a merger? Maybe I'm, a Twitter shareholder, say, hypothetically. And I'm thinking to myself, well, what if somebody wants to come and take over my company? And, I think they're bad for the company, or I think they're bad for society. And I'm worried that the board of directors is either going to have a conflict or they're going to feel that they're constrained by their Revlon duties. So I want to take this decision away from the board. I want to give it to the shareholders, and the shareholders can balance their pocketbook interests versus societal interests, right? I think that's better. So I can come up with a nice story about why this might make sense from a governance perspective, but is it legal under the Delaware statute? I think the answer after Manti is we just don't know, right? Okay, so, well, what about public policy? Right? People identify a handful of what they think are clearly mandatory provisions of Delaware law, and they say, yeah, it's not exactly in the statute, but there are public policy limits. And in particular, they flag fiduciary duties. Well, I've got a concern about whether we really have a public policy limit against contracting around fiduciary duties. Example number one, 102B7, which does allow some contractual freedom. Example number two, section 122.17, which allows some contractual freedom. But more broadly, why are we so worried about fiduciary duties? Think about the analogy to limited partnerships and LLCs, in which we say complete freedom of contract. You are free to eliminate fiduciary duties entirely in your governing documents. Well, what is it that distinguishes the corporation from the LLC or the limited partnership? In many cases, it's not ownership structure. We've got publicly traded LLCs and limited partnerships. We've got LLCs and limited partnerships in which the investors are not particularly sophisticated. If we are worried about, say, market efficiency, there are Delaware cases that say, gee, in the LLC, we're confident that the market can price these fiduciary duty waivers adequately. So why should the corporation be different, right? And I haven't heard a particularly compelling public policy argument, at least that allows me to sort between those two cases. So I'm putting public policy on the table, but I'm not sure exactly what we mean by public policy, right? So third possibility, structural integrity of the corporate form. What do I mean by that? I don't know what I mean by that. What do I mean by that? Well, maybe there's just something about the way we have set up the corporation that requires certain features to be present. Think about, well, what are the key attributes of the corporation? Limited liability, separation of ownership and control, centralized management with authority delegated both from shareholders and the state. Right? Those are at least some of the things that are floating around in my head when I think about structural integrity. And it could be that some contractual modifications interfere with that structural integrity. Just think about it, right? Finally, internal versus external affairs, right? This idea that, well, yeah, freedom of contract is great, but you can't contract away the rights of third parties. Now, I think that is a hard limit, right? So, for example, again, going back to 102b7, the corporation can't contract away director liability for an illegal payment of dividends. Why not? Because the dividend restrictions protect not just shareholders, but creditors. And creditors' rights, arguably, are external to the firm, right? Similarly, when Strine talks in Boilermakers about forum selection bylaws, he says, well, you can't use a forum selection bylaw to govern a tort claim, right? Somebody comes in, even if that tort claimant happens also to be a shareholder, right? The claims have to be about the internal affairs of the corporation. There's scope language in sections 102 and 109 that also suggests limits to internal affairs of the corporation. Only problem with that, after the Shabakuki decision, I'm not entirely sure what the internal affairs of the corporation are, right? There's these intra-corporate affairs, right? Which, you know, all credit to Bill Chandler for making up that concept and getting the Delaware Supreme Court to buy it. Right? But I don't exactly know what internal affairs are anymore. I know that Delaware and California don't think they mean exactly the same thing, right? So, you know, that is a limiting principle I fully concede, but how far that limit extends is a little hard to figure out, right? And here's that limiting language in the charter provision, right? A charter can include any provision for the management of the business and the conduct of the affairs of the corporation, right? That's how far, right? So these contract tools, in theory, can't go any farther than the statutory authorization. Great, right? So, before I get to my examples, I think we'll have more fun with all of these dry principles once I give you a couple of examples. But before I get there, let me just flag one more question, and this goes directly to Anat and Gates' work. Do the limits vary depending on which tool you're using to engage in this contracting, right? So there are some people that argue, Gabe, I think, had this language in an early draft of his first paper on shareholder agreements. I think he took the language out. But some people say you've got greater contractual freedom when it's a shareholder agreement instead of a charter or bylaw provision. And I say some people, it's not just Gabe, right? We see that language in oral argument before the Supreme Court in Shabakuki. Basically, anything is okay if it's in a shareholder agreement. We see that language in a number of the cases. Now, the rationale for that is that shareholder agreements look more like contracts than these other things, the charter and bylaws. I'm not sure that's really true, but I also think that there are sort of heightened problems with doing corporate governance through a shareholder agreement. Right? I'm not saying shareholder agreements are bad. There are lots of things. You think about consideration, right? You think about sort of the individualized issues with buying stock. They belong in a shareholder agreement. But corporate governance, who controls the corporation, what accountability mechanisms shareholders have, should that be something you can contract around in what the courts have characterized as a private document? Right? And think back to what I said about accountability and the sort of key structure of the corporation. Do we take that away if we allow complete freedom of contract in these documents? So I've written about and I worry about shareholder agreements, and I probably will continue to, right? And finally, is it really the case that shareholder agreements are qualitatively different from a charter or bylaw provision? So in the Dropbox case in Shabakuki, we were dealing with an initial provision in a charter at the time the company went public, right? All of the shareholders who bought into the corporation, seems like that was pretty clear consent. Not consent that the directors would put some provision into place afterwards, but consent to a provision at the time they bought the stock, right? Doesn't seem like such a problem from a traditional contract perspective either, although again, I will concede I'm no contracts expert. There are contracts experts in the room, talk to them. All right, so let's consider some examples, and I'll give you 3, okay? So first question, can a corporation go public with a charter provision? So again, like Shaba Cookie, initial charter provision at the time the company goes public saying, we're not going to hold annual meetings, and our directors are going to be chosen by our existing directors. No shareholder elections, none of this messy stuff, right? We don't want to deal with proxy contests and all of that. The board will replace from within. Is that a permissible contractual structure? 2, are there limits on the contractability of traditional shareholder rights? And by traditional shareholder rights, I'm thinking about things like inspection rights, which are not, and I both care a lot about, and appraisal rights and the like, dividend rights, so forth. 3, can a corporation contractually limit director and officer fiduciary duties? I warned you I was going to get back to that question. All right, so let's think about this, contracting out of the annual meeting. So, first of all, annual meeting, election of directors. This is clearly the affairs of the corporation. This clearly is the directors, the officers, the shareholders, right? So it's not external. We've got no internal affairs problem here, right? So from a scope perspective, this is clearly permissible, right? Yes, the statute 211 in Delaware says an annual meeting of shareholders shall be had for the direction of directors. But Nancy told us shall isn't determinative, right? That language in the statute, we can take that into account, but we're not bound by that. The statute says shall in a bunch of places. We need to do something more, right? So what is the something more? How do we go about analyzing that? Is this, or is the election of directors an essential, a fundamental attribute of the corporate form? So I talked earlier about centralized management. I talked about board accountability. Do we lose that in some sort of irreparable way if we remove shareholder elections, right? How does Blasius play into this? Blasius says shareholder voting, the shareholder franchise, that's an essential component of the corporation, right? So if you take Blasius seriously, and I will concede nobody does, right? But if you take Blasius seriously, this should give you some pause. Whether Blasius is based on structure or public policy or a little bit of both, this is a big change, right? And you also think about, well, from a market perspective, is this something that the market can price? Or would it be able to price this if we had corporations that adopted this kind of a change? And notice how wonderfully this structure would prevent a corporation from proxy contests and shareholder activism, right? This is the staggered board of the poison pill on steroids. But if Marty Lipton came along and offered this to your corporation, would you take the risk? So those are some of the thoughts that we might have. Now, if you're saying, Fish, this is an extreme case, this is a crazy case, nobody would even think about this as a possibility. Let me ask you, could advance notice bylaws, which are all over the place and which are getting increasingly aggressive, could advance notice bylaws transcend these same limits? In other words, the frame that I've given you, let's apply it to something that everybody doesn't think is too extreme and off the wall. You come up with the same answer. What's the limiting principle? What's the distinction? Because I got to tell you, I can get to very close to the same place with a, what is the word, horse choker of an advance notice bylaw, and I can do it. And there are corporations that have. Okay, so I told you I wasn't going to give you any answers. I'm not. This is like a corporations class. I'm going to give you the questions. The answers will be on the exam. Students, are you listening? All right. So contractability of traditional shareholder rights. right? So we're increasingly seeing this, right? And if you look at, in particular, private equity funded firms and venture capital funded firms, you got a host of shareholder agreements. They deal with all of these kinds of questions, right? And a contractual approach may well be efficient, right? I think there's a lot of room for these big private companies to say, you know, there's something wrong with traditional corporate structure. There's something unduly burdensome, either with these rights or the way they're being exercised, and we should have greater freedom of contract. What I don't think is that the workaround should happen through shareholder agreements. And, right, in particular, I think the analogy to private contract is misplaced, because I think that with respect to these kinds of rights, we're not really talking about an individual right. Why do shareholders have inspection rights? It's not just to protect that shareholder's personal interest in understanding the company and valuing his or her shares. It's to promote accountability. It's a check on that delegated authority. And that check operates for the benefit of all shareholders. And allowing some shareholders to contract it away, right? It detracts from whatever we think of as the value of accountability in promoting a more efficient corporation. And I'm particularly worried because the language in the cases suggests these things are more enforceable if the investors are sophisticated. Well, it's the sophisticated investors that want to have these rights. So when push comes to shove, they can exercise the rights and they can get something done. It doesn't help me that the little guy who's got 100 shares and doesn't have a lawyer, yeah, he or she has inspection rights, but the big investor, right, they contracted them away and that's going to be binding, right? So if you view these as collective rights, then a private agreement, a shareholder agreement is problematic, but some flexibility of contract, maybe in a charter provision, maybe in a bylaw provision, might depend on the particular issue. I think there's room for that. And I think the way private ordering should go is exactly what we've seen in areas like forum selection and proxy access and reimbursement of proxy expenses, right? The issue comes up and the Delaware legislature says explicitly, yes, you can do this. So the legislature makes the policy judgment. And if you can do it, here's how, right? So you can do certain things in a charter, you can do certain things in a bylaw, you can do certain things in a shareholder adopted bylaw, right? There are different mechanisms that go to the public policy considerations. And this idea that shareholder rights are collective rather than individual, here I'm channeling, scary to say this, but I'm channeling Ed Rock rather than Hartens and Gullis, right? Ed Rock says, you know, directors manage a corporation in the interest of the corporation. Hartens and Gullis say, well, we look through it. What we really care about is what the individual shareholders want, right? That individualistic view of shareholders and shareholders' rights, that's exactly what I'm rejecting here. Okay? And of course, this promotes some of the objectives that I have talked about and have talked about in my research, right? Transparency, equal treatment, and in particular, with respect to governance rights in which we're worried about opportunism, a joint process for negotiating over those governance rights, the board and the shareholders, as opposed to a unilateral approach. Okay, final example. Which I think is good. I'm doing okay time-wise, right? Yeah. Okay. So final example, fiduciary duties, right? And I like to talk about fiduciary duties and freedom of contract because, as I said, fiduciary duties are always sort of the poster child, right? How much freedom of contract do shareholders or corporations have? How much should they have? So think about fiduciary duties in a couple of different situations. Oh no, there's subparts. Right, we get to the final exam question and there's subparts, right? But so Delaware just amended its exculpation provision, right? The original exculpation provision until this year said you could only exculpate directors. You couldn't exculpate officers, right? And in fact, in Gantler, the court said, well, that means you can only exculpate officers. You can only exculpate directors. But that's not what the statute said. The statute said you can have a charter provision that exculpates directors. It didn't say directors and non-officers, right? Non-officers wasn't listed in those exceptions like the duty of loyalty. In fact, there were, I think, 6 or 7 states before Delaware made its change in which the exculpation statutes explicitly say you can exculpate directors and officers. The ALI principles had a sort of freedom of contract approach to exculpation, even in the absence of statutory authority. And the ALI provision said you can put in a contract provision exculpating officers or directors. So what if some enterprising corporation says, and there's a lot of debate about should you be able to exculpate officers as a matter of policy? This is back to dual class and staggered awards. This is one of those things with perhaps no clear right answer. So what if a corporation decides, okay, we're going to put in a charter provision that allows us to exculpate both? Is that allowed under the Delaware statute? Or is that prohibited under the Delaware statute? How do we know? If that case doesn't worry you, well, here's another example. Revlon duties, right? Revlon duties aren't in the Delaware statute at all. This is something the courts have made up. It's a common law duty. It's not the same in every other state. There are lots of states. I think Ohio's one. Isn't Ohio? You don't have Revlon duties in Ohio, right? Right. So, so again, right, from a public policy perspective, right, if states can vary in their treatment of this, seems like it's not a compelling, right? You don't have to have Revlon duties, do you?
No one incorporates. Not true.
Yeah, that's a data point. Stupid data point that we don't really know what to do with, ignore it. But should corporations be able to contract around Revlon duties in Delaware? Would the Delaware courts allow such a thing? And if they wouldn't, what's the reason for not? Third, and perhaps the most interesting issue, shareholder primacy, right? So in the current restatement of corporate governance, draft restatement, early stage draft, right? There are 2 formulations of the objectives of the corporation. Right? One is the Delaware states, in which the restatement says directors have to manage in the best interests of shareholders. And the other is constituency states, in which directors are allowed to manage in accordance with stakeholder governance. So what if a Delaware corporation puts in its charter, hey, we want to allow our directors to follow stakeholder governance? In other words, can you contract around shareholder primacy in your charter? And again, I'll make it easy for you contract types. Let's put it in the initial charter, right, at the time the company goes public, so everybody has advance warning and nobody feels like their rights have been yanked away from them, right? Midstream adoptions raised, I will grant you their own questions, right? But can a corporation do this? And in particular, can a corporation do this without converting to a public benefit corporation, right? Is shareholder primacy an optional feature of corporate governance that you can contract around? Now, I don't know the answer to any of these questions, but let me suggest that these questions make us think hard about exactly how much freedom of contract we're willing to tolerate. And to the extent we don't think that freedom is absolute, what principles should we use? What principles should the Delaware courts use? What principles should the council and the Delaware legislature use in determining the limits of contract? So that's my talk. Those are my questions. The answers will be on your exams. But I welcome your thoughts. I just
Go for it.
I actually, there's so many, but I wanted to start with the previous slide on what's your take on the public benefit corporation? Do you think that they should convert, not convert? I know you said it's a question, but
Thank you so much. First of all, this was amazing. I'm like, I want you to discuss all of these things. Can we continue for a few more hours? Okay, we'll lock you up here. So I have three. One is with regards to the public benefit corporations, right? Because as you know, we have this debate. Some say we don't even need it. We can do this now. We don't need this thing. And Delaware is, changing and changing and changing, trying to make this public benefit corporation easier to convert. I don't see that many conversions and some. And so I'm wondering on that. That's one. And the second, there's currently in front of Delaware this issue of what to do with the gap that we have in the literature, right? With regards to private ordering. And as you know, they've been leaning towards, as you showed in the beginning, allowing private ordering. And so with what we know, and I'm still trying to figure out with the mandatory provisions, right? Where did they come from? Do you think it's going to change the way we think about the corporation? Or we're not going to look at the corporation as, from the contract theory anymore, if they won't allow that one? And I don't know what they'll do. I know it's in front of the court right now. I've been trying to push them to tell us, as you know, in Jewel. And by the way, Professor Fish is the first one to cover this. That's in your shareholder agreements. That's why I wrote my paper afterwards. You see footnotes supporting it and you see footnotes against it. So I'm thinking, so which one is it?
Well, if I were on the Delaware court, I could give you a more conclusive answer, but then I might not be in the majority, so who knows? No, so let me take the easier question first. What about PBCs? And I think that PBCs are an easy way of dodging the question about what contractual limits there should be, right? Because you can say, well, okay, we don't just decide whether you can contract around shareholder privacy, just go and form a PBC instead. But that's kind of the same as saying, well, we don't have to decide about freedom of contract in the corporation because you can go form an LLC, right? That doesn't really tell you anything. And I think actually the question should be asked in the opposite way, right? What are the essential features that make a corporation different, right? What do you get? What do you know you're getting when you buy stock in a corporation as opposed to shares in an LLC? And there, fiduciary duties are hard, right? Because I think there is an argument, well, even if you can contract around fiduciary duties in an LLC, maybe you shouldn't have as much freedom in the corporation. But does that mean no contracting around fiduciary duties is permissible? And I think what the legislature has told us is no, the answer to that is not true, right? Some contractual freedom, even in the corporation, is okay, and you see it in the statute. And my inclination is to think that the legislature is going to allow a lot more freedom, right? And I think that's why we see that amendment to the exculpation provision. I think if push came to shove, the Delaware legislature probably wouldn't be averse to greater contractual freedom on shareholder primacy. Right? Now, that's not the same as saying we're waiving fiduciary duties altogether. I don't think the legislature would go that far. But I think fiduciary duties are a little bit different from corporate structure. Right? I think the balance of power between officers, directors, and shareholders is actually a key feature of the corporate form. And what partnerships and LLCs give you is more flexibility and therefore more unknowability about what that structure looks like, who really has the power. And I think for the corporate form, that's problematic. I think if you think about, well, what do I get off the shelf from the corporation, right? I know what the rules are. I know who calls the shots. And if directors choose directors and shareholders make operational decisions and things like that, it's not really a corporation. And I think that has implications not just for investors, but also for third parties and also for the state. And so that's how I've moved from your first question to your second question.
Can you share with us a little bit? You're on the ALI committee, right? Restating corporate governance. And there's a lot, going on with that. So what's going to be? What's the...
What I have no idea what's going to be, but we're at the early stages, obviously, of the process. Charlie, next.
Yeah, I have a million questions I could ask. I mean, just following up kind of on what Anant was saying. asking about, I hear the phrase off the rack or off the shelf for, is there some benefit? I mean, what is the value of, instead of having a single corporate form that you can within it do anything you want, having separate ones where these are the features you can change. If you're an LLC, you can waive duty of loyalty to an extent you can't in a corporation. If you're a PBC, you can favor other stakeholders over stockholders, and you can't in the C corp. Is there any benefit to keeping those conceptually distinct?
I love that question, because that question makes me state explicitly something that probably should have been in my slides and wasn't. And that is, I think there's a huge efficiency to simplifying the extent to which private ordering can occur, right? I think there's a real cost to analyzing complex firm-specific contract terms, right? I start off the semester teaching my students some LLC and limited partnership stuff. And those contracts are so complicated and they're so dense. And I think about, number one, public markets. And sure, we've got institutional investors, but today most institutional investors are index funds and they're not doing the complex work of analyzing these things. And I'm not sure whether the market really is, right? But I think it's a problem if you've got that degree of complexity. And I think the corporate form is designed in part to say, okay, on a bunch of basic features, you're going to know what you're getting, right? At the end of the day, you might have 2 classes of stock or 10 classes of stock or 1 class of stock, right? There is some variation, but infinite variation, I think, is problematic, even from a market or capital investor perspective. And I think that simplicity is limited to the public corporation, right? I mean, one of the things that we see right now in big private corporations is a lot of complexity. It's one of the reasons I think that private corporations today choose to go public. But even those complexities in the private sphere, right, they're in part due to, as I said, some of these shareholder agreements that I think might go too far. They're in part complexities about capital structure and cash flow rights and things like that, right? But they're not as complex as the equivalent in the non-corporate form. And I don't think they should be, right? I think there's a choice.
Yeah, I mean, I tend to think of it along Sharon Steel lines, right? Where you want to have some standardization of terms that allows you to at least know what the essentials are from a tear sheet type of
Exactly, yes.
type of frontispiece, right?
Yeah, I think that's exactly.
So I want to start with your first example of an annual meeting and ask you, what do you do with Haship? In which Chancellor Allen, rather, is clear that this is he says one of the few mandatory rules of Delaware. And then after the case, the legislature amends the statute, and they amend it in a pretty weak way. So, and it's been a while, but Chancellor Allen's views are still pretty powerful. And so the question is, why doesn't that still have purchase? And then the second question, a little bit related, but it goes back to your exchange with Charlie just now, in the sense of that complexity is an evil in some setting. If in fact that's so, that's a reason to limit private ordering. And you gave us a lot of should questions. That's an answer. So why is complexity different? And I would include a few more things that are with that. And you did oversight, transparency, standardization. I mean, the corporation itself limited, the common stock is the greatest example of standardization to create value. And it made possible to limit the liability. So I think I'm interested in how far you would go in saying that standardization and its offset complexity is something that can be preferred. And sorry to throw in the third thing, but in your first example of a list of examples of private ordering, perhaps the one that goes in that list is choosing Delaware versus somewhere else. That's private ordering. And it's an end run to almost everything that you might put in terms of standardization and complexity. So the question is, are there any limits on being able, do we end up with federal incorporation? So that's three broad questions.
Yeah, which I probably can't even remember, but I think your third question actually answers your second. Because yeah, you can choose to be in Delaware or not. And I flagged a couple of areas in which Delaware law differs from the law of some other states, like until recently, officer exculpation, Revlon duties, right? But oddly enough, with all this freedom of choice, corporate law in the United States is pretty darn standardized, right? Most of the features that I've been talking about apply across the board, whether you're in Delaware or Nevada or South Dakota, you know, the features of
But your
stock,
example-
shareholder
your
elections.
example was Delaware doing something different. Could they in run another state by, I mean, I think you may be right that this is the most common, but the whole point of private ordering is to let you change for specific situations, and do we trust that process or not?
Well, but what I'm saying is that you've got two things going on simultaneously. You've got differences in what the statutory defaults are. And you may or may not have differences in the extent to which states allow private ordering. And I say may or may not, because most of this contractual theory comes out of Delaware. We don't have a whole lot of cases in other jurisdictions that are talking about freedom of contract. We don't have a whole lot of West Coast unicorns that are not Delaware corporations, and in which the legality of these shareholder agreements or the enforceability of these shareholder agreements is being litigated. So it could be that what I'm talking about with respect to contractarianism is something distinctive in Delaware or a broader principle of corporate law, and I don't really know. But what I do know is that the essential features of corporate law seem pretty consistent from one state to another, right? And it kind of suggests, it kind of goes back to Charlie's point about standardization, right? It suggests that even though states are willing to compete, right, they're only really willing to compete at the margins, that they too see a value in standardization. And, you know, if you came in with a corporate statute that dramatically changed a lot of the features that we teach in corporate law, you know, that complexity, that lack of standardization might be more costly, even if the changes individually were viewed as efficient or desirable for some set of corporations. Done?
Yes, for maybe one more question.
Oh, sorry.
Yeah, no, go ahead.
So this was great. Thank you so much. This was like one of the most interesting hours I've had in a long time. Thank you. So that's the exam, right?
Yeah, you
So-
did it.
So I haven't taught corporate law in about 100 years, so I'm a little bit out of my depth on that. I do teach contracts, and I had a couple of questions for you about it, or observations about contracts. So I thought I heard you say, well, a shareholder agreement really shouldn't be understood as a traditional contract. Is that a fair?
When it's dealing with corporate governance.
Characterization,
yes.
right,
I mean,
so-
what I'm doing is I'm kind of separating it out, what I think are the personal features of a shareholder agreement from what I think are the governance features, recognizing that that may not be a very precise line.
Right, and I guess I would just push back and ask, what are courts supposed to do if or to the extent it's not understood in contractual terms? And you don't have to answer the question now, but I was sort of wondering about that. If it's not a contract, what is it? And maybe the answer is it's interpreted and applied and enforced according to corporate governance principles and standards rather than contractual ones.
That would be a great answer. Write that
Yes,
down for me. I like that.
Exactly.
Number two, I think you were talking about collectivization and the idea that, you know, what we should be thinking about is what's in the interest of the shareholders as a collective rather than on a personalized basis. And the question for me that always comes back to, well, who decides and how many you know, if can a rogue minority hoodwink the majority, you know, if the majority just wasn't paying attention on a collectivist theory? And the answer should be yes, right? If they're, you know, whether it's through advanced bylaws or something like that. And what then stops that from happening? And I think that's what you're wrestling with. The third thing, and this really is more of an observation, the question is, I think the way I think about mandatory versus permissive is analogous to the distinction between substance and process. And what's so interesting about private ordering in this sphere is that it has, you know, I think it's increasingly invaded or try to capture rules about process. And I think that's where at least I get most nervous, because if it's all about checks and balances and it's all about sort of, you know, some measures of accountability, then ultimately what we care about is contracting away all of that stuff. So if you go and think about what contract is about, like it is about freedom, but it's also about not giving up all of your freedom. So I can't contract away, I can't contract into slavery, for example. There are certain things that I just can't. And perhaps those are analogous limits, even if we, you know, we would, I guess, import into our thinking about private ordering in corporate law, are thinking about limits to the freedom of contract in contract theory and doctrine. So that's it.
Yes, those are great points. You have to write them down.
Yeah, I'll send you. I'll send you.
But in a way, I feel like your third point partially answers your first point, right? Because, right, if it is really a contract, you're saying, well, okay, but there are these limits even in contract that we could rely on. I guess, and not being a contract person, but I've always had the suspicion that those are pretty weak limits. And so that's kind of pushes me back to your first point, which, you know, saying, you know, that might not be enough. On the sort of minority hoodwinking the majority, I mean, that sort of gets back to this distinction between the corporation's interests and the shareholders' interests, right? And, you know, that's a hard point, but some of, in my second category, when I'm talking about sort of traditional shareholder rights, in part, those shareholder rights are also a check against shareholder majoritarianism, right? And the same way you may or may not like those checks in the democratic process, you might not like them in the corporation. But you think about inspection rights and appraisal rights, right? It's shareholders saying, well, maybe the majority of shareholders reelected this board, but I think there's a problem. Or maybe the majority of the shareholders approved this merger, but I don't think it's a fair price, right? And so if that's part of the corporate structure, right, then we're a little bit worried about, you know, just saying, well, we'll defer to the majority. And, you know, that's, in the Manti case, I think the court, and particularly the majority and the dissent in the Supreme Court, kind of struggle with that as the rationale for appraisal rights. And I think that bakes into this, I flagged public policy, that might be part of your public policy considerations.
So I called it early. We have time for one more question. We don't have to take another question.
More questions?
Well, actually, I do have a follow-up question, which is about the PBC. I'll be talking about this for a minute later, but does it offend Revlon to convert to a PBC?
So, you know, that's a question that I have worried about, that I have asked, and it's not clear to me what the answer is. And in part, it's because the PBC today is kind of weak, right? I mean, we don't really know whether stakeholder governance in the PBC actually means sacrificing shareholder interests. We've got all of these, I mean, when Viva converted to a PBC, it said, hey, we're going to convert to a PBC because this is the way of maximizing shareholder value. And I thought to myself, and they said that it's in the privacy statement. And I said to myself, wait a second, you're converting to this thing that says you don't have to maximize shareholder value as a way to maximize shareholder value. You know, I'm sorry, I'm just not a sophisticated enough practitioner. I don't understand that theory, right? But you know, so you know, if you tell yourself we're maximizing shareholder value, and of course, maybe it's not just for the managers or for the directors who are approving this, it's also for the shareholders who are fiduciaries who are approving this, right? So can BlackRock vote to convert a corporation to a PBC If it acknowledges that that might be sacrificing shareholder value, arguably it can't, or arguably that's a second order agency problem. And we haven't really confronted it. And we haven't confronted it because the PBC really isn't a big commitment to stakeholder governance, and because shareholders retain control. So to the extent that shareholders aren't necessarily happy with what the board's doing, they can still replace the board. You're favoring, customers too much. Let's put somebody else in there, But and this goes back, and not ask this question about PBCs as well. If the PBC were stronger, I don't know. I'd be worried. And by the way, again, think about minority rights, right? Conversion to a PBC. What about the minority shareholders who say, wait a second, right? It's all good for you, but this corporation is in my retirement account and I don't want to sacrifice economic value because, I want to be able to afford to retire.
Charlie, you have one more question?
This would be a much narrower question, but a hobby horse of mine is the inability to waive liability to stockholders for illegal acts. And I mean, you were drawing a distinction between rights and duties to third parties, right? Dividend rights that implicate creditor rights. And I think illegal activity is sometimes swept in there as being, well, that's, you're violating duties to other people. But of course, if shareholders waive liability to themselves for the criminal acts, that's not exculpating the directors from facing criminal liability from criminal law, right? From public law. Is that out of place in 102B7?
So cool. Again, you asked a great question. So yeah, my slides were woefully incomplete because this is also something that is super relevant. And it's also super relevant because I was actually teaching Miller against AT&T yesterday. I was thinking about exactly these questions, right? So, typically, and certainly at the time when 102B7 was adopted, it was our understanding that illegal acts weren't protected by the business judgment rule anyway. So to the extent that 102B7 was kind of like a business judgment rule on steroids, so it doesn't mean it had to go that far. Miller against AT&T, of course, gives you all of the policy rationales why we don't want directors to have the freedom to engage in this, and we don't want it to be up to, arguably, just is it good for the corporation from an economic perspective. So I think all of that's fair. But the bigger point that I want to make is, I gave you a chunk of 102B7 on the screen. The Delaware exculpation statute is actually quite distinctive. If you look outside of Delaware, other states have very different sort of policy limits on exculpation. And it's not just this issue of directors versus officers, how they deal with things like illegal acts, intentional illegal acts, for example, which are quite different from illegal acts, right? Knowing violations of the law, violations only of criminal law, right? So there's a lot of room to kind of make those kinds of choices. And if you were thinking about this from the perspective of, okay, private ordering, corporations can or should sort, I can't imagine a corporation sorting itself into a state for the sole purpose of taking advantage of the exculpation provision. But, kind of suggests that there's a lot, the way Delaware has struck this balance isn't the only way, isn't necessarily the right way. And it's led to, I think, the development of substantive law in Delaware in some ways that might be inefficient and difficult, like this concept of bad faith. Right? Bad faith in Delaware law is what it is because of 102B7. Now, when I teach bad faith, I have a kind of hard time with it. And if anybody has really good slides or notes on that, I would welcome them. Right? But you think about, well, gee, if we had a little bit more of a bare bones statute, if we had more freedom of contract here, would that help or hurt? I'm not really sure. But what I am sure is that the Delaware statute and the way it is isn't the one right answer.
Okay, I think we're going to end at that note, and to thank Professor Fish for being here and giving such a wonderful